Just want to thank the team here from DRM for providing this resource, among many other supports that they've provided to the coalition over the last month, helping keep our restaurant industry moving forward during this unusual circumstances. So our deepest appreciation and gratitude for all of your work, and also for presenting this information session today.
Great, thank you very much, Sue. So again, my name is Walter Judge. I'm an attorney at Downs Rachlin Martin, and I am a litigator, and I am chair of our food and beverage law practice group. So it's great to have you folks from the Vermont Hospitality Coalition in the audience. Let me introduce for you the panelists you're going to be hearing from today. The first is Beth Rattigan. She is the chairperson of our labor and employment group. And the second is Ben Travers, who is an associate in our labor and employment group. And the last person is Scott Jaunich from our real estate and commercial group. And Scott has been following events regarding PPP and the CARES Act extremely carefully. So we have great resources for you today. Today is Wednesday, June 17th, and we are recording this presentation regarding PPP and employee issues. And just a reminder that this is not specific legal advice to any particular person or organization on the webinar, but it's general guidance that we hope you'll find helpful. So with that, I'm going to turn it over to Beth, and we'll get started. Thank you, Beth.
Okay, thank you. Good morning, all. Hopefully, do you see the screen?
Did, and it disappeared. There you go.
Okay, there we go. Sorry, folks. Good morning, all. So we're going to be talking about effective workplace planning strategies, and we welcome your questions. We'll try to answer as many questions as we can at the end of each of our presentations. Please use the question and answer part of this to type your questions in rather than the chat function, because that way we can just keep an eye on one function and we don't have to look at both, so we try to get your question. So I'm going to just give some overview of the basic aspects, furlough versus layoff. Ben will be talking about unemployment issues and the WARN Act implications, and then Scott will talk about some of the PPP loan and other federal law CARES Act implications. So first, to clear up what's been some confusing language for folks is the difference between furlough and layoff. And there isn't necessarily a difference. There's no legal definition that defines either one. But generally, when we talk about furloughs, we mean a temporary layoff, whereas if it's a layoff, we mean a more permanent layoff. Those are loosely used terms. You will hear people use both of those terms at the same for meaning the same thing. But in terms of furlough, there are some differences that are important to note. Is that because a furlough typically refers to a temporary leave of absence, the employees are expected to return to work after a furlough. They're expected that they could be called back at any time during a furlough. And you can, in most circumstances, continue providing health insurance benefits during a furlough versus you couldn't do so during after a permanent layoff, because that's considered a termination, whereas a furlough is temporary. So it's an impact on benefits, and it may impact unemployment. Previously, the Vermont Department of Labor would not have allowed unemployment benefits during a furlough. But this whole COVID situation has, as I'm sure you know, caused a lot of upheaval in everyone's lives, but certainly at the Department of Labor. The Department of Labor has tried to implement policies to help workers along the way, so that furloughed employees are still entitled to unemployment if they otherwise meet the conditions, even though they may be continuing to receive health insurance benefits during that time. So that's a change from the normal law during this COVID period. So layoff, as I mentioned, is generally considered a permanent separation due to lack of work. And the difference with layoff versus furlough here is that a layoff, which is considered permanent, would trigger COBRA. COBRA is the federal law that requires you to give notice to employees about their rights, and it gives them the right to continue their insurance, their health insurance benefits for a period of time after they leave under the same policy and for the same amount of money, although generally they are responsible for paying that premium. One thing to keep in mind that if you are furloughing or laying off employees, that if you have exempt employees who are not paid hourly but are paid a salary and who meet the definition of being exempt under the Fair Labor Standards Act, so they're either executives in that they manage people, or they're administrative in that they are in charge of the operations of a division, or if they're a professional, those exempt employees must be paid for the full week of salary in which they're furloughed or laid off, even if they only work part of that week. For hourly employees, of course, you only have to pay through the time that they actually worked. So who will be let go is a question. Now, I'm sure that you folks in the hospitality restaurant business have already made a lot of these decisions. And you may be at the point of saying, who's coming back? How do we decide who's coming back, or who do we want to come back, and who do we not want to come back, and or we want people to come back and they are not willing to come back. So those are all scenarios that are happening as we speak for a lot of different employers. So I think the thing that's important to think about when you're either calling people back or laying people off is making sure that you are doing so in a non-discriminatory manner. So I think you can establish criteria for deciding which employees will be let go. For instance, you may have decided that you have too many wait staff, or you have too many of one particular area, and you decide to let people go. It's okay to establish criteria according to the job function, but you do have to be careful about disparate impact. You don't suddenly want to say, okay, we're going to let everyone go who's over a certain age, or we're going to let everyone go who's has a family, or we're going to let anyone go who's pregnant, or we're going to let anyone, because all of those issues can implicate discriminatory actions that you certainly want to avoid. And you should document how you decide who gets to go or who gets to stay, or who you call back versus who you don't. And I think that the thing here to keep in mind is, as long as you have legitimate reasons, for instance, you have a job category, or you have a business need because of reduced service needs, but it's just based on how, I need 3 waitstaff people and 2 back of house people, then that's okay if it's that sort of criteria that doesn't belong to a protected category such as gender, age, religion, and all the other categories that are protected under law. The issues about layoff, if you're going to decide, we just don't need that many people, we're going to lay everyone else off. COBRA is implicated, as I mentioned, so you have to give notices, and people are entitled to continue health insurance if they have it. You have to be cognizant of PTO payout. You don't necessarily have to pay PTO out if someone's on a temporary furlough, but if you're terminating someone in a more permanent layoff, then you're going to have to pay. If you have a policy that requires that the PTO is paid out, you're going to have to make that payout. You probably don't have anyone that has employment contracts or unionized employees, so you don't have to worry about contracts. But if you do have such employees, then you need to look at the contracts, because the contract will govern what you need to do. A notice of termination is generally a recommended step to take. And then you can think about do we want to use severance agreements? And in some circumstances, if you know that you're never going to want this person back, or you're changing the way you do your business, there are some employers in your industry that are considering severance agreements, and written severance agreements where you pay someone some money, and in exchange they sign a general release that releases you, the employer, from any liability in connection with their employment. And there are a number of circumstances when that can be useful, particularly if you have a situation where employees have potentially raised some issue, or if they're a member of a protected class and you're concerned about something, then you should consider and speak with legal counsel about a potential severance agreement where you pay money to someone in exchange for signing a release. And when you do that sort of thing under a layoff, if there's more than one person that you're laying off, then you have to consider the ramifications of that under the Older Workers Benefit Protection Act. And this only comes into play if you're actually paying a severance and asking for a release. If you're getting a release from liability from an employee, then you do have to consider the Older Workers Benefit Protection Act, which I'll talk about in a minute. Of course, there could be alternatives to layoffs, and some employers, and I'm sure you're using some of these tactics already, but reducing hours and reducing compensation, flex time, compressed work week, or job sharing. Sometimes those are workable. It depends on your workplace and what the job is. But certainly those are alternatives that can make your money go further under these uncertain times, or at least in these interim times as you begin to reopen. So if you're considering a permanent layoff, you can think about a voluntary plan first before you go to a mandatory severance situation. But keep in mind that if it's voluntary, you get what you offer in terms of if anyone volunteers, you have to accept that, and you can only offer it to some and not others based on any category, protected category. So for instance, you could say, we're going to offer a voluntary leave or voluntary termination program, a voluntary severance program for people who have worked for us for 20 years. And you include everyone in that. Or you could say everyone in our marketing department will be offered a voluntary severance. So you want to pick a category that makes sense rather than individuals necessarily. And if you're going to pick individuals, you have to be careful about that. And anyone who volunteers, you have to accept. You can't say, no, I don't want you to leave because you're too good. I want that other person to leave because they're not so good. Can't do that. Once you make that voluntary offer to individual employees, then you've got to accept whoever volunteers to be laid off. If you are going to go with an involuntary severance, as I mentioned before, there are certain circumstances where when that's beneficial, if there are particular issues with employees, and you would pay some money in exchange for a release. You can't have a release without giving that employee something of value. The release is not effective unless that employee receives something of value. And so if you're going to do that, and there are circumstances when it's helpful, then you do have to think about very specific criteria, and you should again check with counsel because these are very specific circumstances. But there are things that you need to do. And if you're laying off 2 or more on a permanent basis, under the Age Discrimination and Employment Act, you have to do a number of things. And you have to provide, one of those things is you have to provide the titles and the ages of all the people who are eligible for the layoff, and all of the people who were considered but not eligible for the layoff. So you essentially have to give the ages of everyone was considered in order for that person who's signing the release to make an informed decision about whether or not the actions that you're taking are legitimate and whether or not they have an age claim. And so it's considered an informed release of their waiver of their rights, but it is essentially giving them the information they need to make that decision. But it's not to be done lightly by the employer. It should be done with counsel because there are some traps for the unwary when you go through that. You also must give 2 or more people who are being laid off under a severance agreement 45 days to consider whether to sign it. And so essentially the offer to pay them remains open for 45 days. Assuming they agree during that time, they can agree sooner rather than later. But once they sign, they have 7 days to revoke their agreement. So we generally advise that nothing be paid to the employee until that 7-day revocation period ends. And then you make the payment to the employee and you, the employer, have the signed waiver so that you can rest assured that that person is not going to sue you down the road. So all of these considerations have to do with potential discrimination claims being brought against the employer, and that's the consideration here when you're worried about letting people go, particularly if you're picking out individuals. And if you're picking out individuals based on performance reasons, and we know that happens, it's important to have the performance issue documented in some way so that you have that prior to the decision to terminate. So that's a very quick run through of kind of some general considerations in layoffs and severance. And I'm happy to take any questions before we turn it over to Ben.
Thank you, Beth. Right now, I don't see any questions.
Okay.
So we'll move ahead, but thank you for the reminder, Beth. I encourage attendees, if they have questions, to use the question and answer button at the bottom of your screen, and we'll try to answer them as we go along. So I'm going to turn it over to Ben.
Okay, Ben.
Thanks, Walter. As folks mentioned, my name's Ben Travers. I'm an associate attorney with our labor and employment group based in Burlington. Beth and I and our employment group have been busy these past few weeks for all the wrong reasons, having to help employers in all industries deal with some of the toughest decisions in both their business and personal lives. And I know that the last few months have hit the hospitality industry particularly hard. Personally, I've been following and was happy to sign on to your Don't 86 Us petition, and my family has otherwise tried to make an effort throughout all this nonsense to regularly get takeout and delivery from local establishments, and I'm excited to see that many of you have been able to open back up a bit here. But I also, of course, recognize that you've had to let people go or furlough people or whatever the term you may use, as Beth just went over. And that others may be considering having to let even further people go here in the future. So some additional considerations to consider on top of what Beth just mentioned. The first I'll go through very quickly, and the reason why I'll go over it is because it might apply to a couple of you, or if you have been Googling or looking at other resources as to what you need to consider in going through layoffs, one of the things that may come up is referred to as the WARN Act. The reason why I say it may only apply to a couple of you is that it's a federal law that only applies to employers of 100 or more employees. I think there's only 100 or so employers in the state of Vermont with 100 or more employees, but nonetheless, this is just a brief primer with respect to what it is. The WARN Act, from the federal law standpoint, requires that employers give 60 days notice of a plant closing, which would basically, you know, it's termed in sort of manufacturing plant factory, but that term plant would apply to a restaurant or to a hotel or to a bar or really any single establishment, or a mass layoff. And it requires that notice be given not only to their employees or any employee union, but also to the state dislocated worker unit in Vermont, that's the Vermont Department of Labor, as well as the chief elected official of local government. So here in Burlington, for example, the WARN Act would require that you give notice to the mayor. In some other towns, that may be the select board or a town manager, as an example. Now, there is an exception to that 60-day notice period for unforeseeable business circumstances. Many employers that are required to give WARN Act notice, of course, when COVID-19 came around, were unable to provide that 60-day notice. And there's a pretty good argument to be made that that was because of unforeseeable business circumstances. But just because you may have those circumstances does not waive the requirement that you provide this notice. You're still required to provide the notice to the greatest extent that you can. And the WARN Act looks at employment losses during 30 and 90-day periods. And this is enforced by the courts, such that if employers fail to provide that 60-day notice or fail to provide it as soon as they're able to in the event of unforeseeable circumstances, employees could sue their employer for not providing that notice. Again, just very briefly here, when the WARN Act refers to what an employment loss is, it's really referring to a termination or a layoff that exceeds more than 6 months, right? So many employers have had to let folks off temporarily. And if that temporary layoff or furlough is not extending beyond 6 months, then you don't need to worry about the WARN Act. And the other thing is that if you are an employer that's covered by the WARN Act, meaning under federal law you have more than 100 employees, your employment loss needs to have affected more than 50 employees over that 6-month period. And as well, that number needs to be at least 1/3 of your workforce. Now, the sort of last thing I'll mention here on the WARN Act is that if you have had a short-term layoff or a layoff that you thought would be short-term, and it's becoming clearer that that may now be extending beyond 6 months, then you would be required to provide this WARN notice under those circumstances. Again, I very much doubt that this is applying to very many of you, but thought we would provide a primer. There is also in Vermont their own version of this law, which folks many times refer to as sort of a mini WARN Act. This applies to employers with 50 or more employees. So unlike the federal law with 100 or more employees, the Vermont law applies to employers with 50 more employees, and the requirements are largely the same, right? It requires that you provide 45 days notice to the state and 30 days notice to employees, their union, or the local chief elected official. Similar definitions here with respect to what a mass layoff here as to what triggers it. It's a permanent employment loss of at least 50 or more employees at one or more sites during a 90-day period. So it's more likely that for a Vermont employer, the Vermont Mini WARN Act may apply than the federal law. But as we've all been going through these COVID-19 circumstances, the Vermont Department of Labor has made clear that they are not actually enforcing the Vermont Mini WARN Act at this point in time. If it applies to you, it's still to your benefit to err on the side of caution and to provide notice, but just know that if you're having a whoops moment right now, thinking that you should have done this in the past, the Vermont Department of Labor, which is the entity that would enforce the Vermont law, has said that they are not enforcing it at this time. So that's it with respect to the WARN Act, which now takes us to some unemployment considerations, which may be the issue that's of more interest to you all. So as I suspect many of you know, the Vermont unemployment law was changed after this pandemic started. There was a new law signed on March 30th of 2020 that really expanded the circumstances under which Vermont employees would be eligible for unemployment benefits. And one of the biggest ways in which it did that is that historically speaking, if an employee were to voluntarily quit their employer, they're typically not considered to be eligible for unemployment benefits. However, now, if an employee voluntarily leaves because they're subject to a quarantine order, either from their healthcare provider or from state or federal government. If an employee has to leave because they have COVID-19 symptoms or have been exposed to someone who has COVID-19, if they belong to a high-risk group and have to voluntarily leave because of that, or if returning to work would present an unreasonable risk of being infected with COVID-19. And then finally, if an employee is voluntarily leaving because they have to care for an individual who fits those earlier circumstances, or to care for a child whose school or care facility, which now that it's summer, could be a camp or something along those lines, if they have to leave for those reasons, those folks, even though they're voluntarily leaving, may be eligible for unemployment benefits. However, if an employee voluntarily leaves, the employer is relieved of charges to their experience rating. And that term experience rating is the figure that determines how much an employer has to pay into the unemployment system in taxes. So if an employee voluntarily leaves, even if they're eligible for full unemployment benefits, you as an employer should not see an impact on how much you're having to pay into the unemployment system. The other change to the unemployment law with respect to these experience ratings is that employers are also at least temporarily relieved of changes to their experience rating if they had to lay off employees because of business circumstances related to COVID-19. I suspect that obviously many restaurants, bars, and others in the hospitality industry, of course, had to lay off their folks for reasons related to their coronavirus. And those employers should be relieved of charges to their experience rating, but there is an important exception to that, which is that in order for that relief to remain in place, employers, as they reopen, need to extend job offers back to those who they previously laid off. So if you have laid off someone because of the coronavirus, they receive unemployment benefits, and you do not extend an offer of reemployment to them, you could end up seeing a change to your experience rating. So an important exception to remember there. And again, you just need to make the job offer. If an employee then turns the job offer down, you have satisfied your obligation to at least attempt to rehire that individual. The other thing I would note for folks on the call is that now, just as in the past, past employers may still see experience rating charges. And what I mean by that is, if you had an employee a year ago who you terminated or who left for reasons completely unrelated to the coronavirus before this was even on our radar, and then they left and they got another job somewhere else, and then lost the job from their new employer because of the coronavirus, the State Department of Labor looks back about a year to determine what someone's unemployment benefit should be, and they look at wages that they've earned from past employers. So you may be getting some things in the mail from the Department of Labor indicating that your account is being charged for an employee who left you a year ago, and wondering, what's going on with that. So that would be the reason for that. I've put here sort of in red and bold and underlined to look out for incorrect charges, because I have heard that when the Vermont Department of Labor recently switched over to an automated system to try to process all these claims they've been going through, that the system has sometimes been mistakenly charging past employers where they should not be charged, right? So if you're a past employer and someone voluntarily left you, you should not be charged for anything. Even if you paid wages to that employee within the past year, you shouldn't see any changes to your experience rating. But I have heard that there's some glitches in the Vermont Department of Labor system here, where they've been mistakenly charging past employers. So be careful about that. If you see some notices coming in that don't seem right to you, where you have an employee who you think or past employee for you, who you think you should not be charged for, be very careful for that. And certainly if you have any questions about it, feel free to reach out to us. Finally, the last thing that I would mention on this, and this has been a question that a lot of employers have been asking as they reopen, is what if an employee doesn't want to come back? The unemployment system has been relatively friendly here over the last couple months or so, with new federal benefits that, on top of the Vermont law, gives employees an additional $600 a week. What I can say to that is that Vermont has said that if work becomes available and it's safe for an employee to return, that if an employee then refuses to return to work, that may then disqualify them from receiving benefits. And again, as I mentioned previously, you should receive, if an employee is being charged for benefits onto your experience rating, you should receive something from the Vermont Department of Labor outlining what those charges are. If you get that for an employee who you have offered work to and they have refused it for one reason or another, there are instructions on that form as to how you can inform the Department of Labor that you offered that work. As I mentioned previously, over the past couple months, there has been, under the Federal CARES Act, an additional $600 per week available for COVID-related unemployment. That will remain in place through July 31st, but that additional $600 a week will not be available to employees after July 31st. There's been some efforts in Congress to extend that, but not as of yet. There's some additional information here with respect to nonprofit employers, and many nonprofit employers in the state are actually self-payers. Their employees receive unemployment benefits through the employer itself and not through the state unemployment system. I don't think that applies to very many people on this call, but certainly there's information there if folks want to read through it. That's it with respect to the WARN Act and unemployment. Certainly, looking at the Q&A here, I don't see, Walter, any questions, but if folks have any follow-up questions on unemployment and considerations to make as folks return or don't return to work, would be happy to answer them.
That's correct. Thank you, Ben. We're getting into the sort of the heart and soul of this presentation, where people may have concerns about rehiring employees who don't want to come back, and so on and so forth. So I'll continue to monitor the Q&A, and with that said, we'll turn it over to Scott Jaunich now, who's going to talk more in detail about the PPP program.
Thanks, Walter. As a preface, let me indicate to you, I don't know how many people on this program have received Paycheck Protection Program loans. We call it PPP. The program is open until June 30th. That's the last day they will accept applications. There is money available. I know many in the restaurant and hospitality industries were reluctant to participate after quickly grabbing onto the program because of the uncertainties. On June 5th, there was a recent amendment of the flexibility of the Paycheck Protection Program called the Flexibility Act that extended the forgiven period from 8 weeks to 24 weeks. So if there are people on the program who have not yet taken loans because of the uncertainties, it is worth revisiting the program to see if you may be interested now. But I would move quickly and work with the local lender to see how that may be beneficial to you. What I want to focus on is the employment aspect for those persons who are participating in the program. The way the PPP works is you apply with a local lender for a loan, which is based on 2.5 months of payroll. And then you have a forgiven period, which was 8 weeks. It has now been extended to 24 weeks or through the end of the year, December 31st, whichever comes first. And then you can seek forgiveness of your properly expended funds for both payroll and non-payroll costs, so that loan amount basically becomes a grant. And any monies that you don't expend become a 1% loan. The term was 2 years. For new loans, it will be 5 years. And the Flexibility Act allowed that you would have the ability to work with your lender to extend your loan term from 2 years to 5 years. So if you have a loan and you're worried about the period of your back-end loan, work with your lender. So, but I want to focus on here for purposes of this program is the employment aspect. As you may know, if your employment changes during the period of your forgiveness, your covered period, the 8 weeks or the 24 weeks at your election, your forgiven amount may be reduced by the proportion of your employment loss. So the way the PPP calculates employment is based on a full-time equivalent. So the first step is to determine on a 40-hour week basis how those employees are calculated. You determine a weekly average, and then you need to compare that to a period, and there are several periods which you can elect your option that would be most beneficial. The CARES Act also allows a more simplified calculation where you can assign a value of 1 to a full-time employee and half to a part-time employee and run the same math and compare your averages. If your employment count becomes reduced during the covered period, it's the proportional reduction of your total forgiveness amount. So it's not just your payroll costs that get reduced, it would be your non-payroll as well. So your total amount of loan forgiveness will be reduced by the percentage of your employment count reduction. So go ahead, Beth. Because there may be, especially in these industries, in the hospitality industries, employee modifications, the Flexibility Act has modified a little bit how we can excuse employee counts so it doesn't work a reduction of our forgiveness amount. We've called those safe harbors or exemptions. Employees that leave or are laid off or are furloughed do not count for purposes of your forgiveness reduction if they have refused a written offer to return, if they voluntarily resign, if they're fired for cause, or if they have voluntarily requested and received a reduction in hours. What I would emphasize here, and I know Beth mentioned it earlier, but documentation is going to be key. The SBA has indicated that loan amounts over $2 million will be audited. They've reserved the right to audit any loan amount under $2 million at any time. There are document submission requirements when you apply for forgiveness. So if you are seeking exemption of an employee who has otherwise left, you should be able to document both the written offer to return and their written refusal. If they don't have a written refusal, you should document your effort to secure that written refusal. Because the forgiveness program is still relatively new and the rules are changing under the Flexibility Act, it's really hard to give concrete guidance, but I would emphasize document, document, document. The other change here that I want to highlight is under what the SBA has termed an interim final rule, which was implemented on May 22nd. If you have an employee who has rejected an offer of reemployment, you are now required to notify the Vermont Board of the Employment Board that they have rejected that offer. We don't know yet how that is going to play out. The SBA said they would provide on their website a copy of the notice or the means for doing so. We don't know what means is necessary. But again, if there is an audit and you seek to excuse an employee who left because they failed to accept a written offer, but you have not notified the state, it may be that your forgiveness would be decreased because your exemption wouldn't be allowed. So if you do have employees, you've offered the opportunity to return to work and they've refused, you do need now under the CARES Act to notify the state if you are seeking forgiveness of that amount. So go ahead, Beth. The Flexibility Act added several new exemptions for forgiveness as well. Loan forgiveness, if there is an FTE reduction, will be disregarded if the borrower can document in good faith that A, they were unable to rehire individuals who were either furloughed or laid off as of February 15th, and you were not able to hire a similarly qualified employee for that position. Now, that's been extended to the end of the year, December 31, 2020, because we now have the 24-week under the Flexibility Act. What's not clear, because the SBA has not issued promised guidance yet under the Flexibility Act, is what happens to an employee who was let go and then brought back, and then let's say in September subsequently it becomes necessary to let them go again. It's not clear whether that hurdle repeats or whether it is satisfied once. So I wish I had better guidance for that for you. But what I would suggest is that you keep a close eye on that. We do have a COVID resource page on our firm website at DRM. And we are keeping that current, but as those rules come out, it will be very important to know whether it's a one and done or whether we need to continue looking at employment rates through the end of the year, which I suspect will be the case. The other significant change under the Flexibility Act that is of significant benefit to this industry is you will be excused for employee reductions if the reduction is based on an inability to return to the same level of business activity as existed before February 15th due to guidance or compliance with COVID laws, whether it's through Human Services, OSHA, governor's orders that relate to sanitation, social distancing, worker customer safety requirements, and it's COVID related. So for example, if a restaurant is forced to operate at 50% capacity and that causes a reduction in your need for employment levels, that may be excused. So again, document everything. I don't know yet how this rule is going to be implemented. It was just put in place on June 5th and the rules aren't yet in place from SBA. Significantly, and I'll use the example of a restaurant reduced to 50%. While the restaurant may be entitled to an exemption from its employee reduction, a secondary service, let's say a food supplier or a linen service, that also now suffers the 50% reduction. You're using 50% fewer tablecloths. The benefit doesn't extend to the secondary industry. It is just the primary employer at this point, as far as we know under the rules, that's going to get the benefit of that exemption. So I think that's it. If there are questions on the PPP, I would be happy to discuss them. I could go on at length. We have had webinars just on the PPP. I guess I'll make one more point. There is a similar reduction for wages in addition to employee count, and under the PPP, you don't double dip on your reduction. So if there is a reduction of both hours and wages, you treat it just under the hours reduction under the FTE workforce, and you don't have to also double calculate that salary. But if there are questions, I'm happy to answer them. If there are specific questions, our contact information is provided on the slides, which I understand are going to be made available to all of the participants. Pick up the phone and call, and I'd be happy to address your specifics under, once we have an established relationship. So I think that's it, Walter. I'm happy to answer questions. We could go on all day on PPP.
Okay, thank you very much, Scott. That was very helpful. We do have some questions. Some of them may have been answered or partially answered as the presentation went on, but let me try to address a few of them, and we'll take it from there. So there's a question from Tim. How do employers go about reporting to the state that they have made qualified job offers that have been refused by the laid off employee? Does one of you want to quickly address that?
I can take it under the PPP. As I said, the SBA has not yet indicated how that's supposed to be done for their purposes. They have, in their guidance, promised that that instruction will be provided, and it hasn't yet. So at this point, whether it's a letter notice, I would make an effort and document it, is the best I can provide if you're seeking forgiveness amounts and an excuse from your forgiveness.
All right, thank you, Scott.
And Walter, it may be worth the question may also be with respect to unemployment benefits. If you've made a qualified job offer and someone's been refused, how can you inform the State Department of Labor? And the answer to that question is there's a form that's put out by the Department of Labor. It's their F-35 form. It's not the fighter jet. It's the Department of Labor F-35 form that you can find online. I think I just accidentally sent it to all panelists. I'll send it to all panelists and attendees in the chat, where if you have a former employee who you know is receiving unemployment benefits for which you are being charged for, and you have extended an offer of reemployment to that individual and they've refused it, you could fill out this form and send it into the Department of Labor.
Okay, thank you, Ben. There's a question from Sue. You, Ben, had mentioned on your last slide a provision around safe, the word safe. Can you elaborate a bit on what that entails?
Yeah, so that's a really good question. So first, an employee can voluntarily quit and still receive unemployment benefits if they believe there's an unreasonable risk that they would contract COVID-19 upon returning to work. And then secondarily to that, if an employee was previously laid off and you have made an offer of reemployment, that employee may appropriately refuse that offer of reemployment and still receive unemployment benefits if it would be unsafe for that individual to return to work. It's going to be interesting to see how that works in practice from the Department of Labor standpoint, right? The Department of Labor is, as I suspect many of you have heard in the news and perhaps heard about from your own employees, or maybe even you personally, they've been overworked and very understaffed as of late. So I will be curious to see how the Department of Labor administratively determines, if an individual is saying, I believe it's unsafe or it presents an unreasonable risk. It will be interesting to see how they make those determinations. But technically speaking, the way it should work is, as long as you as an employer are following whatever guidance has been issued for you by the state, whether it be physical distancing, everything else that's out there, as long as you are following that guidance, then for most employees, that should not present an unreasonable risk that they will contract COVID-19 upon returning to work. For another employee, depending on their circumstances, if they have some underlying condition or what have you, that may change the dynamic a bit. But generally speaking, that is how we understand sort of this question of safety will be assessed, is are you following the guidance? And as long as you are, employees should have to return if they want to continue receiving unemployment benefits.
Okay, thank you, Ben. So a question from one of the attendees, and this may be a fairly common occurrence. So the COVID a pandemic started, and you were subject to shutdown, and during that period, some of your employees may have completely moved out of state. Does that affect your procedure for offering to rehire, and if they refuse because they're out of state, does that make any difference?
Under PPP, and I'll address it there, the answer is no. If you make an offer to them and they refuse to accept it, it doesn't matter that they're out of state. The secondary aspect of that is, can you find somebody else to fill that position? And if you satisfy both of those, then it wouldn't count as a reduction of your forgiveness amount. But it's not specific to that individual on rehiring under the CARES Act, under the PPP program for purposes of your loan amount.
Okay. We have a few more questions that have just come in. One of the attendees asks, what is the date PPP FTE need to be back to work?
Yeah, under the PPP, the date back to work is going to be, it was June 30th. So let me back up. PPP loan recipients originally understood they had an 8-week covered period, which ran from the date of the loan disbursement. Now, under the Flex Act, they have 24 weeks or the end of the year, December 31st, 2020, if that comes first. Under the Flex Act, as the PPP is now implemented, we need to bring people back before December 31, 2020, or the end of your 24-week period, if that's sooner. So the difficulty becomes, as I mentioned, what happens if we let somebody go and bring them back, but then have to let them go again? It's not clear whether that's going to hurt you because you have one person less on your employee count at the end of your covered period, even though you had already brought them back and satisfied the hurdle. So we're waiting for SBA guidance on how that's going to work. But as of right now, the plan to bring somebody back in order to get full forgiveness amount without reduction is going to be the earlier of 24 weeks after your loan was dispersed or the end of the year, December 31, 2020.
Okay. And here's one that looks like this might be a toughie. If you accepted PPP, but then returned funds before May 18th, are you able to reapply under Safe Harbor? If you returned, if you return the loan proceeds after May 18th, are you able to reapply?
It's a good question. For the benefit of persons on the program who may not understand the full extent of the question, there was a question about the certification which was necessary to get a PPP loan, where the borrower had to certify that the loan was necessary for the continuing operation of the business. And there were a number of large businesses and some publicly traded companies, including Shake Shack, that took significant loan amounts, yet had other funds available. And the SBA got very aggressive and threatened enforcement, and there was a political ruckus. And the SBA implemented a safe harbor program, which said if you repaid the funds, they would presume that your certification was made in good faith and they wouldn't seek enforcement action. So there were a number of businesses that returned loan amounts that they had already received under that safe harbor. So they were avoiding potential enforcement risk. The answer to the question is, I don't know. The PPP says you were entitled to one loan. There are some commentators that say if you took a loan and you repaid it, that was at your option. You're not entitled to a second. There are others who say if you returned it under the safe harbor, now with the Flex Act and with money still available, you should be able to reapply. So that's a question that you should ask your private lender to see if they're willing to accept and submit through the SBA portal a second loan application because the first was fully repaid. I don't know. The short answer is we don't know yet.
Okay, thank you, Scott. So I'll note that we're running up against our 1 hour time limit, but we do have a couple of more questions. We'll see if we can sneak them in very quickly. Bruce has a couple of questions. One is about tips for tipped employees, and the other is about the 8-week period versus the 24-week period. I'm gonna, if Bruce is okay, I'm gonna allow Bruce to talk, and maybe he can quickly ask his questions. So Bruce, you can go ahead.
Hi, thank you. So on the first one, what I'm trying to ask is, so if you have a tipped employee that is accepted, to come back under the terms of the PPP, and you've committed their certain level of pay, but let's just say for argument's sake, they're actually earning half of that committed pay in tips because they're back and working. How does the calculation work? In other words, will I only be eligible for reimbursement for the portion in which I'm actually paying, or would it be eligible for the entire amount that they're earning, even though, like I said, in this example, the employee may be earning half of that committed amount through, through tips, which I'm not actually paying?
Yeah, you would be entitled to take the tip for purposes of forgiveness. Tips are included as salary and wages under the calculation of your payroll expenses.
Okay.
And if you can't document the actual amount of tips, there's actually SBA guidance which allows you to make a good faith estimate. So again, document your estimate if you can't document the exact amount, and that should be sufficient for purposes of PPP forgiveness.
Okay. No, we have it documented because
Yep.
it's the reported tips portion, so we know, we have that.
Yep.
Okay, thank you very much. And then the second question is, what I'm asking, I guess, is that, they've extended this period from 8 weeks to 24 weeks. And what I haven't been able to understand is, does that mean that, in our case, we did take the PPP and, the clock started, if you will, we're 6 weeks in 6 weeks, this is the 6th week of the 8. So my question really is, what is the 24-week extension doing? Is it extending? I couldn't understand how it could actually allow you to extend the use of the money to 24 weeks from 8, since the whole calculation was based on your payroll over 8 weeks. So does that just mean you have 24 weeks to decide what 8-week period you want to use, or is there some way that you're really extending the usage 24 weeks?
The answer to the question is, as SBA has implemented the 24 weeks, it is 24 weeks to expend payroll and non-payroll expenses for purposes of your forgiveness calculation. So understand, when you applied for your loan originally, it wasn't 8 weeks, it was actually 10 weeks. It's 2.5 months of payroll expenses. It was the basis for your loan amount. So now you take that loan amount, and instead of having to spend it over 8 weeks, you're enabled 24 weeks to spend that amount and still seek forgiveness.
Okay, thank you.
Yeah, there are businesses that took loan amounts early that have fully expended their loan amounts on allowed payroll and non-payroll, and it may be beneficial to those businesses to elect to proceed immediately with forgiveness and submit an application and get that loan off their books. The SBA has allowed the borrower to elect whether to use the 8-week or the 24-week period. My guess is for most, especially in this industry, 24 weeks is going to enable you to spend the full amount of your loan or a greater amount of your loan on payroll and non-payroll allowed expenses, which will increase your amount of forgiveness. So,
okay, can I just ask one more follow-up to this? Is that, I guess where it was confusing to me is that, if you've asked all your employees to come back and committed a certain level over 8 weeks of pay, then now by extending it to 24, I don't see how you can honor your commitment that you made to your employees based on, the 8 weeks, unless I'm missing how I was originally supposed to, ask them to come back. I'm just a little confused. Well, I guess so that's kind of the basis of the question. I'm a little confused as to.
Yeah, no, I understand. If you made a loan request based on 10 weeks of payroll, and we're coming up to the end of that 10 weeks where you've made a promise to those employees to bring them back and pay them for that period, we have difficult employment decisions coming up if we're not able to fully open and we don't have sufficient revenue to cover it, because it's no longer going to be PPP money. It's it's back to traditional employment money.
Yeah.
So yes, there is no extension of the loan amount to cover the 24 weeks. What the 24 weeks does is it gives you a greater period to spend the same amount of money. So you're right. It was based on 10 weeks and now it's 24. So it's not going to cover the full payroll and non-payroll expenses for the full 24-week period. So there are some difficult employment decisions coming up.
Okay, thank you very much.
So thank you, Scott, and thank you to everyone who presented and all the attendees. I think that that last question and answer addressed the last outstanding question. Clearly, if you have more specific questions about your particular business, I'd obviously encourage you to speak to us or another attorney who's familiar with PPP and employment issues. And also, obviously, some of this is legal guidance and our best attempt at this point to interpret the PPP, particularly with so many unknowns still out there. But you should always, of course, consult your accountant. And so I think that wraps it up. But again, if you have further questions, feel free to address them to Sue or directly to us, and we'll attempt to answer them for you. So thank you very much for attending, and really good luck to all of you, and we're rooting for you to get your businesses back open and thriving. So thank you very much.
Super. Thank you all.
And we'll end it. Thanks. Bye.